Good morning, and thank you for joining our panel on the Biden administration, Building Back Better. I'm George Fibby. I'm a partner in the Energy Regulatory and Litigation departments here at Baker Botts, and I joined the firm from the U.S. Department of Energy, where I was the Deputy General Counsel for Litigation, Regulation, and Enforcement. For this panel, we have myself as well as three of my distinguished colleagues from Baker Botts. We have a number of attorneys here at the firm who've spent time serving in government and in various federal agencies. It was hard to pick just four, but here we are, and we have, I think, a good program plan to try to talk about what we've seen in the first week and what we expect going forward with the administration. So let me introduce our panelists, and then we'll offer a few initial comments, and we'll be taking questions throughout. So please feel free to submit your questions through the chat or question function, and we'll try to address those either at the end or as we go. So joining me for this panel this morning, first of all, is Maureen Olhausen. Maureen is the chair of the firm's Global Antitrust and Competition Practice. Maureen joined Baker Botts, before Baker Botts, that is. She was a commissioner and acting chairman of the Federal Trade Commission. Her practice focuses on antitrust, privacy, and data security and consumer protection investigations, both in the U.S. and abroad. And so Maureen oversaw both enforcement aspects and merger review and various issues that are near and dear to the hearts of directors everywhere. So Maureen will be joining us first, and we'll go over some of the things that we might look out for, particularly with the FTC and the Antitrust Division of the Department of Justice. Next, we also have Bridget Moore joining us. Bridget is one of the co-chairs of the firm's litigation department. Bridget, her practice focuses on securities enforcement, in particular, internal investigations, white-collar defense, and other securities litigation. And Bridget, before joining the firm, spent time as an enforcement attorney at the SEC. And finally, we have Jeff Wood. Jeff joined the firm from the Department of Justice, where he was the acting assistant attorney general for the Justice Department's Environment and Natural Resources Division, which is the part or component of DOJ that deals both with enforcement and civil litigation around environmental issues on behalf of all the various agencies. So Jeff worked with all the various agencies of government. He is a partner in our DC office in our environmental practice group. So with that brief introduction, I'd like to just start with Maureen, and Maureen, ask you what you would like to point out as kind of key takeaways that we might expect going forward, and things that we've noticed already in the first week with the Biden administration, particularly looking at the FTC and the Antitrust Division at DOJ. So Maureen, please take it away.
Great. Well, thanks, George. Delighted to be talking on this panel. It's a very interesting, I think, dynamic time. But some of the things that I think kind of as a baseline here is to realize that the previous administration was actually a pretty active enforcer on both antitrust and privacy issues. I think we will continue to see that focus, the activity level, it will continue to grow, but I think the Trump administration surprised some people by bringing a lot of big antitrust cases, brought one of the first vertical merger challenges in a long time right out of the box with the AT&T Time Warner. It didn't turn out very well, but when they've issued some new guidance, brought big privacy enforcement cases, the big Facebook settlement. So that's the baseline that we're starting from. So right now, it's a little bit unclear that there hasn't been, names put forth yet for the permanent heads of the Antitrust Division or the Federal Trade Commission. So right now at the Antitrust Division, we have a career person who is acting, and there has been Gene Kimmelman named as a kind of a transitional advisor. Gene had been at the DOJ Antitrust Division during the Obama administration, but that is sort of a transitional, transition period nominee. So questions still remain about, who the leadership will be. At the Federal Trade Commission, so we have Becca Slaughter, who was a Democratic commissioner. She's been elevated to acting chairman of the Federal Trade Commission. She has just announced a slate of acting heads, all career staff people. So that's, I think, a strong indication that they expect to be nominating someone to be the permanent chair of the FTC. But for the interim, starting after Friday, the FTC will have 2 Democratic commissioners and 2 Republican commissioners for the foreseeable future until the Chairman Simon's, or now Commissioner Simon's, seat gets filled, and the other Democrat currently on the commission, Rohit Chopra, has been nominated to be head of the Consumer Financial Protection Bureau. So that seat will also need to get filled. Now, the commission can actually do quite a bit, even with a 2-2. When I was the acting chairman for a year and a half, it was just myself and a Democratic colleague, and we brought a lot of enforcement. So it is not necessarily a recipe for gridlock. Really a lot can get done. So I think expect continued, challenges on, borderline mergers, on, conduct. There seems to be some appetite for perhaps revisiting some of the ground the FTC lost in the Qualcomm case in the Ninth Circuit. One of the things that may be coming down the road are the Democratic commissioners had objected to the new vertical merger guidelines that had been put out and had said, don't count on these, even though they were long in the making and really, really needed. So I would anticipate additional vertical merger challenges. It may not happen while it's a 2-2 commission, but once they have a full slate of commissioners, that'll probably happen at the Department of Justice as well. One of the other big challenges here is, an agency, whether it's Department of Justice or the FTC, has a number of limitations on what it's able to do, even if you have leaders who want to be very aggressive. One is the existing case law, and the other is resources. And to take the resource issue first, the FTC has very limited resources right now. We've seen leaked memos from their executive director saying, we can't hire anybody else. Active litigation uses up a lot of resources. It's very expensive for experts and things like that, particularly on big antitrust cases. So while they have been moving to challenge, they have a lot of big cases in the pipeline, at some point they're going to kind of hit the wall of like, how do you pay for all those things? Do they have enough bodies? So that's another one of the challenges. DOJ also has, a limited budget, and the antitrust agency's budgets have not kept up with the growth in the economy. I think that's fairly well understood at this point. The other thing is the law, right? So antitrust law, mergers, they might challenge some more mergers. They might be more aggressive on some conduct kind of investigations. But the question is, can they win it in the courts under the current law? I mentioned the AT&T Time Warner merger. The DOJ was not able to win that in court. So there's this question also happening right now, this great discussion happening about whether Congress should change the antitrust laws. Should there be presumptions put in place that if you are an entity over a certain size, the presumption flips and you have to, it's not up to the government to prove that the merger is anti-competitive. It's up to the acquiring company to prove that it is not anti-competitive. Those are some of the things that are being considered. additional obligations for sharing of assets or essential facilities. So some things that would be quite a big change, but all of those things are being discussed. So one other thing I'll mention on the antitrust side, and then I'll touch briefly on the consumer protection side. So another thing that for acquisitions that is really being examined closely is acquisitions of nascent competitors. That's become a really big topic in antitrust. And there's rule changes for the HSR rules out there for consideration. There's comment on it happening right now, rulemaking. And there's a study about that the FTC did on 5 large platform companies, tech companies, looking at 10 years of acquisitions. There might be things coming out of that. But that is going to be an area of intense focus. So if you have deals that previously were not getting a deep review at the agencies, they might get a deep review. So just pivoting briefly to consumer protection on the FTC front, privacy has been a huge issue, will continue to be a big issue. Companies have sometimes faced quite large liability, right? So the Facebook case, that was an order violation, so it was a $5 billion fine there. That's kind of eye-popping. And new obligations that appeared in the Facebook settlement that required new board committees to oversee how Facebook was using data and its privacy obligations. One other thing that's really coming, and it's outside of the privacy area, is the FTC's been pushing, or the Democrats on the FTC have been pushing to name high-level executives as defendants in consumer protection enforcement. And that would really be an unusual development. Normally, for a big company, the order would just be against the settlement, or the complaint would just name the company, because the individual executives, it's not like an alter ego, small company, fly-by-night kind of situation. But there's a big interest and a big push towards saying, oh, the executives themselves should be named. So I think that's another thing that we'll see get more interest and more traction in the Biden administration. So I'll stop there and look forward to hearing from my fellow panelists and answering any questions.
Thanks, Maureen. Now Bridget, let's go to you and hear a little bit about the SEC. And I think in one of the earlier sessions this morning, there was discussion of additional disclosure rules and that sort of thing. So why don't we just kick it to you and tell us a little bit about what we can expect.
Great. Thank you so much. Yeah, I will absolutely get to the disclosure points, but kind of starting where Maureen started in terms of setting the table and where we are today. With Jay Clayton, we were very much saw a commission that was focused on capital markets and the promotion and support of capital markets. I don't think that will change. I do think there'll be an increased focus on enforcement, which I will get to. But Gensler, who is going through the confirmation process, is an interesting choice because he has the enforcement background, but also the capital markets background from his time at Goldman Sachs. So I think it's going to be interesting to see how he continues on with what Jay Clayton started, but also pivots a bit on enforcement. So starting with the capital markets piece of it and the rules and regulations that have been put in place over the last 4 years. I think that what we'll see is some changes to some of the more hotly debated regulations that went into effect and potential changes there. So just throwing out some examples, you have the shareholder proposal rules. Again, hotly debated, a significant amount of comments around that rulemaking effort. And I think that it's safe to say that this commission may take a look to see, if there should be changes to the rules that had just been put in place. I think another area will be regulation best interest. That again was hotly debated. What is the standard for a broker and his or her customer? Is it best interest or is it a higher fiduciary standard? I think that is something we will absolutely see. And then, going to the disclosure point, for the SEC in particular with ESG, there's two issues. You have the OC issue, the Office of Compliance Inspections and Examinations, looking at asset managers who make certain representations to its clients about the investments it's making. And so there's the angle of, looking to confirm whether those statements are correct and their investment strategies are actually what they are promoting them to be. And then you have what we discussed earlier today, which is, is the SEC going to put some formal guardrails around ESG disclosure? I think all signs are that they will. I think that it's going to take a while. I think that it's kind of understanding what is going to be expected, and having a comment period open and some debate around what is actually helpful for a shareholder will take some time, but I do think it will happen. And then with respect to enforcement, in particular around ESG disclosure, I think that is even further down the road, because I think there's going to be a bit of a learning curve in terms of what companies put out there. And so I think enforcement related to that will be, we will eventually see it, but I think that, it's going to take some time. That is a bit different from what I mentioned before in terms of what asset managers are putting out there in terms of the investments that they're making. And if they're making representations against ESG, that seems, ripe for enforcement. In terms of what we could see with a greater emphasis on enforcement, I think that we're still going to see the protection of the mainstream investor. It will be very interesting to see, and I know that there's been a lot written about this, but it's worth mentioning here, if we're going to go back to an enforcement regime that looks to what was called broken windows under Mary Jo White, which is the enforcement division spending resources investigating and bringing cases based on these non-scienter-based violations. So just essentially what I like to refer to as sometimes as foot faults. So you're talking books and records like violations. They carry lower fines. The collateral consequences are in many cases insignificant, but they take resources. And to Maureen's point, resources in every government agency is always a question mark. So it'll be interesting to see if we go back there. I think it'll also be interesting to see if, while the commission through the Trump administration has certainly brought cases against officers and directors, it was not as rigorous as the prior administration. So it'll be interesting to see in these enforcement cases what the staff is directed to do in terms of bringing those individuals in the company to, as we would call it, to the table in terms of settlement discussions, and see if the pool of people that the staff is going to look to for culpability increases. So I think that's something to keep our eye on also. But it's certainly going to be an interesting time. I think Gensler is a very interesting choice. He helped the CFTC after the financial crisis, so he certainly understands what it is to push rules and regulations through during difficult times. So I think it's going to be interesting to see what he can do. I think probably in a short period of time.
Thanks, Bridget. Appreciate those comments, and let's go over to Jeff. I know environmental issues are important to a lot of the attendees today, and so let's, Jeff, if you could talk a little bit about what we can expect. I think a lot of it's no mystery, no secret, the emphasis that the campaign and now administration has put on climate. It's climate really throughout every agency, but maybe you can give us a little bit of a few insights on some things we might be looking for.
Great. Thanks, George. Bridget, Maureen, it's really good to be on this panel with you. Last year, I was glad to be in Houston for this event. Hopefully next year, I'll be back in Houston again, and hope everybody joining the call is staying healthy and safe these days. One of our earlier panels talked about the speed of change, Steve Solo. mentioning how fast things are happening on the ground. I think we're seeing that certainly in the environmental arena as a lot of the Build Back Better agenda gets fully underway. In the first week, we've seen a regulatory freeze memo essentially staying the implementation of the midnight regulations that came out of the Trump administration. We've seen executive orders on environment and climate already. They've identified 48 EPA rules that they are beginning the process of reviewing and reconsidering. That's an incredibly long list. My own sense is some of those items will fall off their list as they work through the issues, but at least that's their starting point. 31 Interior Department rules are also already on the list for review and reconsideration. And DOJ has already begun to make filings in court seeking stays and advances of pending cases while the agencies get underway looking at the review. So that'll certainly get going here. Tomorrow, we expect the president to make another announcement. If the media reports are correct, he'll announce a one-year moratorium on new federal oil and gas leasing. And so we'll certainly be watching that and see the details there. If you can see the slide, the first slide there on tools for the new administration, I just wanted to talk briefly about in the environmental arena what we're primarily looking at. And each of these can be quite effective in their own right. Obviously, executive orders and agency directives that we've already talked about are crucial to achieving the Biden administration's primary goals. Net zero emissions by 2050, carbon-free power sector by 2035, $2 trillion investment in green energy and green infrastructure, restrictions on oil and gas production and coal production on federal lands. All these things fit already within those directives, but there are also budget priorities that can get shifted, organizational changes that are already taking place. For example, within the organizational toolbox, we saw last week the Interior Department issue a fairly simple directive that purported to simply be a temporary suspension of delegated authority, Order 3395. And George, you may talk a bit more about that, but it was an organizational document affecting the way the agency structures itself and makes decisions, but has pretty immediate impacts on how approvals for oil and gas leases takes place. Enforcement priorities, permit licensing processes, federal state partnerships, private sector initiatives, all things that they'll be looking at. As I think about the regulatory and policy issues to watch and the questions that might be front and center, number one, how quickly can the new administration reverse course? The Administrative Procedures Act puts guardrails around the ability of an agency to flip positions too quickly. So we'll see how fast that process moves forward. On climate, how quickly can the new administration resurrect and update the social cost of carbon, and how broadly do they apply that? I think they'll be pushing the limits as much as possible. Will Congress step in to resolve some of the regulatory uncertainty that continues, notwithstanding the last 4 years, with the efforts to reform the regulatory apparatus? You have, how far will they be able to go in slowing down permitting approvals? It's an area where I think you'll see a lot of questions. What kind of staffing and resources do they put towards processing of project approvals? How quickly and how many roadblocks are put up for review and approval of state implementation plan applications, for example, state SIP programs under the Clean Air Act? Another area where you might see some slowdown and some new hurdles. We do know that some of the new leaders coming in are part of the old team from the Obama EPA. You have Janet McCabe, who's Deputy Administrator nominee for EPA. She served in the Obama administration, had a key role in priorities like the Clean Power Plan. But for the leadership of EPA, they've actually gone outside to the states, to North Carolina, with Michael Regan, who by all accounts has a great reputation and looks to bring in a set of fresh ideas from his experiences in North Carolina as a new leader and a new face at EPA. We're waiting on announcements for political leadership at the Environment Division at DOJ, and that should be coming soon. We'll know that shortly. On the other side, regulatory and now to enforcement, there's another slide there I wanted to put on the screen. Hopefully you have a chance to see that. If we look back over the 10-year trend, there has been a long downward trend in civil environmental enforcement cases that have been opened at the federal level. There are a lot of reasons for this. I mean, lots been written and talked about this, but one is, I think, increasing corporate compliance. Certainly as environmental laws and regulations have become more mainstream and more implemented fully at the corporate level, we're seeing a downward trend. But it's also true, I think, that while the trend has gone down, the complexity of those cases that are being brought continues to go up, and that stayed true over the last several years. What should we expect to see in a Biden administration on environmental enforcement? I think more inspections. If you look back at the 10-year trend, inspections were down, civil enforcement was down, criminal enforcement was down. But looking towards this next year and 2-year period, I think you should expect to see certainly an uptick in the number of inspections. Part of that will be sort of as we come out of the pandemic, a return of inspection resources, both at the state and federal level. Getting back into the field will certainly bring those numbers up and could end up driving up the number of administrative and civil cases that are brought. I think we'll also see more agency information requests, Section 114 requests under the Clean Air Act, for example, two companies checking in on compliance. I think we'll also see a significant increase in the cost of settlement and resolution of enforcement cases. During the last administration, there were several initiatives to curtail the use of third-party payments, supplemental environmental projects, and things like that that are common features of consent decrees. We expect to see those return in full force in the new administration. I also would expect to see a broader understanding of what is required to mitigate for environmental harm. That's at issue in the case. In the last several years, enforcement settlements typically included more narrow views of what kind of mitigation is required. And so we might see mitigation steps, third-party payments directed towards other agenda items for the administration, whether it's climate, environmental justice, or broader environmental remedies. We also expect to see a change from the perspective of national compliance initiatives at EPA and back to the national enforcement initiative focus that we saw in previous administrations. And that could include things like new source review, Section 112R and RMP type cases, and things focused on sectors that might be now more in the crosshairs of the new administration. We also expect to see more parallel and criminal proceedings alongside of civil enforcement, and that also includes the greater risk of individual corporate liability. And lastly, one of the interesting trends that we've been watching at Baker Botts and hearing that might be out there is, the citizen groups have been quite active in challenging the Trump administration's deregulatory agenda, put a lot of resources toward challenging rulemaking reforms at EPA, Interior, and other agencies. The question is, where do those resources go now with the new administration? And some of what we're hearing is that a lot of those resources at the NGO level will be directed towards citizen suit litigation. So we might expect to see an uptick in notice of intent letters that are sent over to companies, as well as FOIA requests to agencies soliciting records about agency or corporate compliance. And then, George, the last thing I'll mention just before we turn it back to you, if I'm sitting at a corporate board level, I'm asking myself, what can I do now to be ready for this? And I guess one thing I would just recommend that our audience take a look at is existing EPA and DOJ guidance on the expectations for corporate environmental compliance. EPA has long stood by its environmental management system guidance, putting forward 12 elements of an effective EMS system. Now would be a good time to take a look at that and ensure that your own corporate program is meeting the latest standards in EMS. DOJ, when they bring an enforcement case, will often take a look back at how compliant your program was relative to their own standards in effect at the time of the non-compliance. And so it's helpful to kind of look through DOJ guidance on the evaluation of corporate compliance programs. It was most recently updated in June 2020, but has been in existence for quite a long time. It'll ask questions like, Does your corporate environmental compliance policy have a clear message on environmental issues, on misconduct not being tolerated? Does it assign clear accountability and responsibility mechanisms? Does it have a clear and effective system of incentives that are integrated into your corporate programs to promote compliance in the corporate workforce? Do you have an efficient and trusted and safe mechanism for employees to raise environmental compliance concerns in a confidential and anonymous way to appropriate corporate officials? So these are some of the questions that I think DOJ asks, and I think it's a good time for, as it always is, for companies to take a look at their environmental compliance programs and ensure that they're meeting the standards. So with that, George, I'll turn it back to you.
All right, thanks, Jeff. I'll take a moment just for a couple comments, a few brief comments on a couple other agencies. First of all, the Department of Energy, where I serve, and as many know, the Department of Energy is less of an enforcement agency than some of the others that we've been talking about, and so there is an enforcement arm at DOE focused on some of its regs, but much of the Department of Energy is dedicated toward supporting various energy research and endeavors, all the national labs and various other programs. And so one of the things that sort of on more of the positive side of what to look for and what to expect is that it's very clear from the administration's statements that you're going to see certain offices at the Department of Energy, for example, the Loan Programs Office, the Energy Efficiency and Renewable Energy Office, and others are going to be very, very active and active in ways to try to support renewables, to support various types to support investment in renewable energy projects or other innovative projects that can help the administration move forward the low carbon agenda. And so I think that's sort of let's not forget that there's going to be this other emphasis, less on cracking down in some areas and on affirmatively promoting and pursuing certain aspects. So if your company is in that area or is doing innovative things that may help advance a low carbon future, then you may be very well positioned to work cooperatively with folks like the Department of Energy or some other aspect or components of the administration. And then when it comes to the Department of Energy, for those who are in the manufacturing space, it's clear that the administration is going to be very active in promulgating energy efficiency regulations. And I think an open question is exactly how the administration is going to navigate nuclear issues. So how to support the nuclear industry and whether that's a critical part of reducing emissions or whether there's reticence to go in terms of full-throated support for the industry. So that's just a brief word on the Department of Energy. On the other hand, I think a very, very important part of the new administration is going to be FERC. So the Federal Energy Regulatory Commission is going to be very active. That's another independent commission in where, at least for a period of time, it's still going to be a Republican majority on the commission. That will turn over possibly by the summer of this year, maybe a little bit later. But in any event, there's going to be a lot of activity at FERC, particularly issues like allowing carbon pricing mechanisms to be in some of the regional transmission authorities and organizations. And so you'll see, again, consistent with the theme of everywhere that the administration can consider and think about ways to incorporate climate issues and climate concerns into the way it does business and regulates, you're going to see that. It's clearly a focus. So there, the minimum offer price rule, a variety of rules that are important at FERC. And in particular, they're very important to the renewable space. You're going to see a lot of activity there and increased enforcement at FERC as well. So that's just a couple comments. And I guess one other thing, Jeff, playing on one of the issues that you raised, we did see an order come out from the Department of Interior recently. Again, here we are, we're 1 week in, and so what's happened in the first week? We've had several major executive orders and kind of a planned rollout of executive orders steadily. There's expected to be another major order tomorrow on climate issues. But I think it's interesting to see what happened with the Department of Interior order that was rolled out in two respects. What it was a suspension of delegated authority. In other words, saying pretty much any approval or authorization in the fossil fuel space needs to be approved not by the line level career employees, career civil servants of the agency, but rather by the top 9 individuals at the department. So there's always going to be a bureaucratic slowdown in any new administration. But an order that formalized that slowdown by concentrating authority to do more or less anything in the hands of 9 individuals is an interesting way to accomplish it. So I guess number one on it is it's a good example of how what seem like minor internal organizational decisions can actually perhaps be under the radar, or not under the radar, but other ways, that is, to accomplish, essentially a moratorium on fossil fuel authorizations for permitting and leasing and other things. The second point on that is it's a very good example, and I think we'll see more of that. So before the administration took place, there was a lot of speculation. There are ways that an administration could allocate employees away from certain functions. So everybody who used to sign permits now goes and does something else, and the permit processing kind of grinds to a halt. Will the administration do things like that? So this was a good example of an action that looks like that. The second thing is how that was reported. And so I think a lot of general counsels out there are immediately fielding questions that I heard that there was a moratorium imposed for 60 days. And, it will sort of fall on the general counsels oftentimes to really break down exactly what action was technically taken. And while the ultimate effect of that particular order may be, pretty much a moratorium on the sort of leasing and permitting, it was technically fashioned as something a little bit different. And so that's the type of nuance and that I think general counsels are going to have to unwind for their directors who need to be informed and want to be sure they understand exactly what's going on, because unfortunately the press often does a fairly poor job very quickly in catching some of the nuance in terms of what exactly took place. So with that, I'll just I'll kick it back to the panelists, and we've had a few questions come in, which we'll try to get. I guess the first one I'll ask is, we're obviously seeing a lot of folks who are veterans of the Obama-Biden administration coming back into government after sort of just a 4-year break and finding their positions. I think we'll see more and more of that. And these are largely folks who are very experienced in government. And so my question is a little bit different. So in what ways do you see that this administration is not Obama 2.0? In what ways do you think that a Biden administration is going to be markedly different from the program that we saw a few years back? I have a couple thoughts on that, but maybe some of our other panelists have something to say as well.
Sure. So let me jump in from the antitrust angle, at least. Much of the progressive criticism of antitrust enforcement, recent antitrust enforcement, was as much directed at the Obama administration as the Trump administration. There was this, kind of sea change in thinking in some quarters, saying that the antitrust consensus of focusing on economic issues and consumer interest, consumer welfare, which, was sort of the standard in antitrust really for the past 30 or more years. The allegations is that, it somehow got it wrong. Acting chairwoman Becca Slaughter has said, well, now antitrust should look at systemic racism, which normally outside of economic values, you're not, sort of importing other values. So I think, whether it's race, racial equity, or whether it's environmentalism or labor issues, there's sort of a whole host of very important issues, but is antitrust the right tool? So to the extent this criticism has been leveled at the Obama positions too, there is some, I think, interest in, and we've seen this shift. I think that people who were in the Obama administration have started kind of shifting their rhetoric to get, I think, more in line with some of these progressive criticisms. Now, ultimately, the idea of putting someone in charge of an enforcement agency, the antitrust division, the FTC, you do want someone who's got some real experience. So I do think they will look to those, to the Obama veterans, but the people who end up actually getting the roles may be taking a slightly different tack or approach than they did when they were in the Obama administration.
Georgia, I think for my part, I think the difference will be, when you had, with the Obama administration, you had a commission focused on getting us through the financial crisis and identifying potential wrongdoers during that time. And a lot of time and resources were put towards that. What we've seen, again, and kind of going back to my other comments with Jay Clayton, a renewed focus on capital markets, promoting the strength of our capital markets, trying to take down some of the hurdles in terms of becoming a public company, trying to increase the number of companies that go public. And I do think that we're going to continue along those lines with, again, kind of more of a potentially a increase or a renewed focus or a renewed look at enforcement, certainly. But I do think that's the difference between an Obama administration and a Biden administration in terms of what is important, where your resources are going to go. And I don't see this administration or Gensler turning away from what the commission has started in terms of promoting and strengthening our capital markets.
George, just to add on to that, from the environmental standpoint, what's different from the Obama administration to this new Biden administration? A couple of things jump out to me. First, in the Obama administration, we saw a real focus on climate change, and every policy issue was viewed through the lens of climate change. That carries over into the Biden administration, but they've certainly added on to that environmental justice as sort of a co-equal with climate change in terms of a priority and a lens through which they view issues. And Nadira Clark, one of our partners, has been hosting a series of webinars and is helping to prepare a toolbox to help companies get ready for this change in focus. But there's a lot happening on climate and also on environmental justice. Also on energy and environment, George, I think it's fair to say that in the Obama administration, the regulatory agenda was focused on constraining coal production and oil as well. And natural gas was viewed more as a bridge, but somewhat in favor in some of the policies. I think looking forward, 2021 and beyond, the policies we're beginning to see, you see natural gas put back in with coal and oil and some of the policies that are coming out, and not as favorable to natural gas as maybe the Obama years had been. So those are two areas. The last thing I just wonder is, how will the courts respond to the Biden administration's agenda? We saw in the Obama administration a lot of skepticism from the federal courts, especially the Supreme Court, which famously stayed the Clean Power Plan in somewhat of an unprecedented manner before the DC Circuit had even had an opportunity to rule on it. Just last week, the DC Circuit issued a decision vacating the Trump administration repeal and replacement of the Clean Power Plan. and leaves open the question of the status of the Clean Power Plan, whether the Supreme Court will step in again. But I think the question will be, will the courts respond with the same degree of skepticism as they did 8 years ago with some of the key Obama administration actions? And I think it's left to be seen there. We did have one slide, George, I might throw up there if it's not out of order, but in terms of where we might see litigation challenging key agency decisions, you expect those to be filed in places where the courts, generally speaking, might be more skeptical of the new administration's agenda. And so we expect to see those filed in places like the Fifth Circuit. Certainly the Eighth Circuit would be another one. Whereas you saw more of the Trump administration challenges filed in places like the Ninth Circuit and the Fourth Circuit, where courts were more skeptical of the Trump regulatory agenda. So how much of it actually makes it into actual implementation will depend in large part on how the courts respond to the Biden administration agenda and whether they deal as skeptically with it as they did in some cases with the Obama administration, and certainly as they did with the Trump administration too.
Thanks, Jeff. And that's a good point. I had wanted to mention the litigation climate as well, because I think it's interesting to look at the litigation landscape going forward, obviously with an administration that is going to be as active as we expect it to be in terms of promulgating new regulations, in terms of rescinding actions that the Trump administration took. I think, the one thing we need to look at is, and companies need to look at is what tools are in the toolbox to challenge those regulations if they sort of are outside the fairway. And so the litigation landscape is different in a couple of respects. So I would make two comments on that. Is first of all, a lot of the regulatory agenda is Obama 2.0. So a lot of it is being picked up and brought forward. Some ideas that were struck down in the courts before, or just never got finished or never got ruled on in the courts, are going to be back in the spotlight again. And so what's different is that presumably both sides or multiple sides of those litigation matters have lessons learned. And so they'll be a little bit different, and folks will try to fix the things that courts objected to, whether that's making a better administrative record and whatnot to help the case. And the second thing is what you mentioned. It's a different federal judiciary now than it was 4 years ago, and with also not just in terms of personnel, but in terms of 4 years worth of regulatory litigation over the Trump administration's agenda, which has created precedents and created interesting cases to look at. So it's I think that's also, we're not starting at the exact same spot as where things were just 4 years ago. So with that, I know we only have a couple minutes left. I'll ask one more question of the panel, and that is just anything that you'd like to mention in terms of how directors or general counsels can mitigate some of the risks that we've described. Jeff, I know you mentioned picking up certain statements and policies and reviewing them, but anything else that the panel would like to offer in terms of and Maureen, I know you mentioned the executives being named in actions and things like that. That certainly gets folks' attention. So any good strategies that you think folks should take a look at now to try to mitigate some of the things that we see on the horizon?
Well, one thing.
Go ahead, Maureen.
Go ahead, Bridget, you go first.
Okay. Just quickly, one thing I would mention, and it kind of dominates the headlines and it will continue to do so, and the SEC promotes it because to the resource point that Maureen started with, it helps them tremendously, is whistleblowers. I would encourage the officers and directors to look at the whistleblower policies within the company, make sure they're well tailored to attempt to keep that individual in-house. Make sure that there's tight programs in place to have benchmarks in terms of when a complaint comes in and how it's dealt with, and the ultimate reporting to the board to the extent that that is appropriate. It will, these whistleblower cases, I think especially during COVID, people are home, people are getting laid off. Whistleblower cases are through the roof. And, you know, it is something that the SEC absolutely appreciates, because with these whistleblowers getting lawyers, it's a whole cottage industry now. They're coming fast and furious, and taking a moment to step back and look at how you handle whistleblowers, and to make sure that there is a culture of compliance, and that there is that is messaged to within the company, I think will serve you very well.
Maureen?
Sure. So I would just weigh in on every company now has, you know, important troves of data, whether it is customer data, whether it's employee data, whether it's, you know, sensitive data that you've collected and used for other purposes. And one of the trends that we've seen is that this is moving from being kind of like a low-level compliance issue to being, you know, a C-suite issue, to being, does your company survive, you know, a big data breach issue, or you know, not just a data breach, or, you know, use of, you know, information in a way that wasn't, you know, appropriate. So I think, you know, asking some questions about what data do you have, and how is the company securing it? I think, and is there a plan in place, you know, if something goes wrong, or kind of some really important issues, because those, I think one of the things that we've really seen is like some huge eye-popping fines, and some, you know, basically controversies that have gone to the heart of some of the operations of some big companies. So it's not just a, you know, the IT department low-level compliance issue. It's one to keep an eye on.
Yeah, George, I guess one of the things I would highlight is also in the enforcement space, to build on what Maureen was saying. As I said in my comments, the price of settlement is likely to go up pretty dramatically on major environmental enforcement matters. If you take an apples to apples comparison of Trump administration settlements with the Obama administration settlements in comparable cases, you often found that the civil fines were relatively comparable, sometimes higher in the Trump administration, but you had much higher supplemental environmental project mitigation costs and third-party payment costs. One question I have, and I think it's something worth considering, is to the extent companies are facing pending or threatened enforcement litigation, evaluating the costs associated with those and the time frame for settlement, and what it would take to resolve a case, as well as whether there are any updates to corporate disclosures that are required relative to the cost expected associated with those cases as they move forward. So I think that's one area to watch. And then on the flip side, the regulatory side, just kind of getting back to how much of the new agenda will actually stick and actually become effective. And one of the trends that has not been resolved, one of the issues that's not been resolved in the courts with any definite outcome, is the scope and extent of nationwide injunctions, and the extent to which one federal court in one state can enjoin a new administration's actions nationwide. There were a lot of efforts in the Trump administration, consistent with longstanding DOJ practice, to oppose nationwide injunctions. And certainly the new DOJ leadership will also oppose them. I mean, I'm not sure what Judge Garland's view will be as the Attorney General, but certainly there will be an effort to bring nationwide injunction efforts to block on a broad scale the implementation of big parts of the new administration's agenda. I think it's an open question how much of it survives. My own sense is that on issues like you mentioned, moratoria, those face high litigation risk. We've got precedents on that. But on areas where they're exercising fair judgment over the line drawing of regulatory standards, that's where they tend to be on safer ground.
All right. So thank you to all the panelists. Thank you for everybody who's joined. We've gotten a number of questions in, which we're happy to answer off on. As they say, we'll be here all week. So thank you for sticking with us, and really appreciate the panelists. It's been a good discussion.